office, the Army, or federal courthouse, and say to them, here's what you must do. They have their own authority, their own area that they have control over, and we don't dictate to them. We only represent them if and when litigation begins. And so it's not a contradiction that I'm representing them, and yet am not able to tell them how to deal with their cases. I hope you understand that. As for some of the other issues that you raised, I know that you contacted me, you contacted my legal assistant, you've written numerous letters to Mr. Christie, and another issue that came up was you suggested for some reason that I would want to schedule today's hearing. That's not true. I did not schedule today's hearing. And in fact, if you review the papers that I submitted to you, in my notice of motion, I specifically asked the court not to have oral argument. But as evident, the point I raised earlier, I do not tell the judge what to do. The judge tells us what to do. The judge decided whatever reason oral argument would be appropriate, and accordingly, I'm here. And
that's correct. It was my decision. I wanted to have oral argument on this case because I wanted both sides in here just so that everybody would have an opportunity to say anything that they wanted to say on the record, just as I let you read that letter, and I'm letting Mr. Anger address you and discuss these various issues. I'm sorry for interrupting you.
No. As for my legal arguments, I think their merit stands for, the paper stands their merit.
Fine.
And I think I hope I've addressed some of your arguments.
Can I answer your arguments?
Well, excuse me, Ms. Kareem, that wasn't an argument that he made. That wasn't an argument.
There are a lot of discrepancies in his statement just now, right?
All right. Do you want to discuss that? Go ahead.
How would you explain to this court and to me why they ignored me that all of the designations of this court never answered my inquiry, never ever answered for my summons? That is a form of discrimination itself. Now, if you were aware, if you are really on the side of the United States District Court, how are you not able to know that they did not answer, they did not respond? Don't you know that when you are being called to the law, you are supposed to answer it? And if you don't, you will be say. That means to say, I was right in the very beginning. So many three judges already saw my justice on my side. Now, you are telling me that to answer the arguments that I wrote to you, to what extent are you saying that this court, that you on the side? How do you know the complete scenario of my case? Did you make a study of how I was being treated by the court? I was physically evicted, okay? Because you have no right to come here anymore. Because at last, I would mention about as lunch sent me to the judge. I happened to understand. Because of providence, I was taught to that just to understand the meaning of slash sent me to the judge. That we go up to the judge with a former ink signature. That never happened. I asked for a transcript of papers, complete summary of the balanced submission of both sides of the party. It never happened.
So before you go through all the litany of all the things that are your allegations, and I'm not challenging your allegations, but I'm responding two ways. First, and most importantly, as I said to you on the phone when you called me approximately a week ago, I believe very much in your best interest to hire an attorney. Because
no, I don't hear that. I am fighting a mafia. You understand that?
Because what?
Support the life. I just thought.
Because
this is very much support my life. Now, what do you mean by that? He sent me to the.
Mr. Carino, please. Mr. Anger is showing a tremendous amount of respect towards you, and I would ask that you treat him with the same respect.
I'm just carried away. I'm sorry. Because it is something that is
I understand. The second point that I was going to raise, which is part of the first, is that I did respond to your briefings. Now, I know you don't like the fact that I filed a motion to dismiss, but there are complicated legal reasons for why I had to file that motion to dismiss. That if you had an attorney, that attorney would be able to explain to you. But I did not address, I've never denied any of your allegations. I'm not saying they're true, I'm not saying they're false. You're right, I have not made a study of your allegations yet, because the first issue I need to deal with as an attorney dealing with these complex legal issues that as a non-attorney I wouldn't expect you to naturally understand. I had to file this motion and ask this court to dismiss your matter so that it be brought to federal court. Now, once it gets to federal court, then, if filed appropriately and done appropriately, appropriately, we might have an opportunity to address the merits of your allegations. At which point, I assure you, I will be forced to make a study of your allegations and determine whether or not they're true.
Okay, excuse me. A lawyer is not medically. Now, explain to me the origin of the word protest. Why is protest?
I'm sorry. Ms. Carino, I'm sorry. We could go back and forth all day on this, but we're not going to, because as you can see, if you look behind you, I have a lot of other cases here.
It was explained to me. The lawyer is not explained. It is the judge who explained to me.
Explain what to you?
Because the judge says, be comfortable with this claim. Do not be upset. Tell me the truth. And if you cannot provide a legal term, I'll take care of them.
All right. What I'm going to do, Ms. Carino, is address the two motions that are in front of me today. Now, before I do that, I want to say to you the same thing that Mr. Anger said to you. If you wish to proceed in this matter, you will be much better off if you get an attorney. Now, I know you're going to say, I heard what you said to Mr. Anger, that you've gone to attorneys and they don't want to represent you, but there are lawyers that will take your case, okay? You can call the Essex County State Bar Association or the New Jersey State Bar Association, and they have an attorney referral service. And they will refer an attorney to you. They give you a number of attorneys that you can call. The issues in this case are complex, and while you certainly are obviously a very intelligent woman, the training that the attorneys have will help you in understanding the complexity and the legal nuances involved in these issues. Maybe I'm wrong. Maybe you do understand them. I don't know, but I think you'd be much better off if you had an attorney. Now, having said that, here today, you have moved for an order of summary judgment in the amount of $10 million against the defendant, the United States District Court. The defendant seeks an order dismissing your complaint without prejudice for lack of jurisdiction. You allege that various employees of the District Court have engaged in actions while in the scope of their employment that have caused the undetermined injuries to you. It appears that you allege both intentional and negligent acts. Such actions include the one clerk's unauthorized opening and returning of documents addressed to the Chief Court Clerk, Mr. William T. Walsh, other clerks, and allegations against numerous employees of the United States. You argue that the defendant defaulted by allowing more than 30 days to pass without filing an answer to your complaint. For this reason, you move for summary judgment and seek $10 million in compensation. The defendant contends that you have failed to properly serve the United States of America. The defendant maintains that you did not have leave of court to serve the defendant by mail under Rule 4:4-4A1. It's required that the summons and complaint be personally served on the defendant. Even if the court were to assume that proper service upon either United States District Judge Garrett Brown or William Walsh satisfied Rule 4:4-4A8's requirement that the service be made on the presiding officer